Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, and you shall be heard. God save these United States, great state of Florida, and this honorable court. Gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. First case on our docket today is the League of Women Voters of Florida versus the Florida House of Representatives. You may proceed.
Thank you, Your Honor. May it please the court. I am Talbot Dallenberg, representing the League of Women Voters and the coalition petitioners in this case. We have joined with the ROMO petitioners to file a brief, and we're authorized to present oral argument for both petitioners in this case. With me are John Delaney with the ROMO petitioners and Adam Schachner, co-counsel for the coalition petitioners. I respectfully request that you reserve 7 minutes for rebuttal. In November 2010, an overwhelming majority of Florida voters approved an amendments to the Florida Constitution establishing for the first time standards for the development of apportionment plans for both the legislature and for congressional districts. This court has had several opportunities to review those amendments. And the things that you've said about those amendments, we think are extremely important for the case in front of you today.
Well, you're not saying, or are you, that the amendment directly answers this question as far as a legislative privilege in Florida?
No, Your Honor.
Okay. And are you taking the position, I know the briefs do, but that there is no and should be no legislative privilege in Florida, so that Judge Lewis's order, which only allows objective testimony about objective facts, should be also quashed because it doesn't allow all of the subjective considerations of the legislators?
Your Honor, I
That's
think,
like a multiple, but
I've got
sort
two
of
questions. One is our submission today is only on the facts in front of the court. It is not necessary for the court to reach beyond the issue of whether or not legislators, legislative documents, and others can be made available to all.
But you're not
parties
taking
in all
issue then
cases.
with the part of Judge Lewis's order that, to me, significantly restricts what you can question the legislators about.
And the answer to that, Your Honor, is that we believe that the rules of civil procedure provide all the guidance that anyone needs. The subjective separation is one that respondents criticize, and we think can be a problem in application. And we don't think it's necessary to go beyond the rules of civil procedure, which provide us all the guidance that a trial court needs. So our submission in terms of legislative privilege is that under the facts of this case, where we have constitutional provisions that specifically state that intent is to be considered, then discovery should be allowed as it relates to the intent of the legislature.
At all on what information can be obtained.
Your Honor,
There should be no, there's no privilege as far as you're concerned, only the privileges that appear in the rules of civil procedure and the rules of evidence.
exactly, Your Honor.
That's what you're saying.
And that's our submission, that there's actually no legislative privilege. We don't ask the court today to go issue a sweeping order saying there can never be a recognition of
Let me
public
ask you
policy
this,
that protects the legislature in one
From a
matter
practical
or another.
From a practical standpoint, I mean, how would the legislature function if each legislator was under the belief that anything he or she may say to anyone else may be something that they're going to have to answer under oath in a deposition or perhaps in court? How can they possibly function?
Your Honor, I hope it would function in accordance with the Florida Constitution. I hope it would stay away from any improper intent in drafting apportionment plans.
Well, you don't, so just again, trying to understand this, Justice Labarga's concern, and I share that concern, is that in the majority of the cases, Mr. Quintero filed many circuit court orders, that in the ordinary course of deciding issues, legislative intent, it appears that those orders were well-founded, that as far as inquiring into the legislative process. So what you want to do is have us narrowly address this issue. Is that correct?
The issue relating to a challenge based on provisions in the Florida Constitution.
But again, I guess I'm asking you the question, is it your position that the constitutional provision at issue specifically intended to overturn any pre-existing common law legislative privilege?
Your Honor, we do not believe that there was any common law legislative privilege. That was abolished in the adoption of the Florida Evidence Code.
But then how, then if there is no legislative privilege, then Justice Labarga's question, which is that how do you differentiate between the ordinary decision-making process that is involved in every legislative session and every legislative decision from this unique situation? Don't we need to, see, I guess what I was hoping for is, I'm looking at Judge Lewis's order, and I think it appears to me he struck a good balance. Now, you're saying you think it's an unworkable dichotomy, and so you, in that way, agree with Mr. Quintero.
Your Honor, I don't think it's unworkable. I don't think it's particularly desirable. I don't think it's needed. Look, we deal, and courts deal with intent every day of the week. We deal with contractual intent. We deal with intent in a criminal context. We deal intent even with bar discipline matters. And so intent is not a stranger. We're not strangers to the concept of intent.
Well, listen, as a practical matter, were you going to depose Senator Gardner and say, well, did you intend to favor yourself when you draft? I mean, isn't it even as a question almost like begging the question? Isn't it those communications that you got a hold of and were produced, isn't that really the core of what you want to inquire about?
Your Honor, we have grave doubts that if we started asking legislators, did you have an improper intent, that'll not lead us very far. Now, let's pause for a second and remember that in 2002, when the legislative apportionment both legislative and congressional apportionment were before federal courts, the legislative parties in the federal case stipulated that they adopted the plans of apportionment in order to favor a particular political party. So there was actually a stipulation in 2002 that was the basis of the plans. Now, we don't expect that kind of stipulation in this case, but we're certainly entitled to inquire into how the plans were developed, how they were drawn, to use the constitutional word, and we should be allowed to ask who was contacted, who was consulted.
But isn't that objective in this case? And it's hard because there hasn't been a deposition yet, so we're kind of looking at it in an amorphous way. But isn't that what Judge Lewis considered to be objective, how the plan was developed, not what they were thinking at the time that they rejected this plan or that plan?
Your Honor, until we get to the discovery, honestly, I can't answer your question.
You don't think,
But
you
I
can't
don't-
say that that's how the plan was developed is an objective fact as opposed to subjective thoughts?
Your Honor, it's possible that this court could draw an order saying you could get to objective facts and describe the objective facts. At this point, we're not sure exactly how the objective-subjective line gets drawn, and so we can't entirely answer you, and therefore, we're a little bit uncomfortable with that and think it's unnecessary. Why do you have to have any rule that's different from any other rule once in ten?
Let me ask you a question about how this fits in the overall body of the law. Do you have any cases where a court in the United States has ordered that a member of a state legislature submit to a deposition in a civil case to answer questions concerning matters related to the deliberations of the legislature and things internal to the legislative process?
Your Honor, I think the strongest case that we've got, there are two important cases, but Baldus from Wisconsin.
Does that case do that? Does that if you've got similar cases or cases you think should be persuasive, you can tell me about those. But are there any cases that fall in the category that I described?
Not in terms of an assertion of legislative privilege, in terms of executive privilege, a number.
I'm not talking about executive. I'm talking about legislators being required to submit to a deposition in a civil case related to matters within the legislative process.
No, Your Honor.
You don't have any cases like that, do you?
No, Your Honor. And so Baldus was an assertion of legislative privilege to protect a legislative staff person, an assertion very similar to the assertion being made by respondents here.
You've got a case that involves requiring that a staff person.
That's right. But, Your Honor, the Constitution is drafted saying that the prohibited action is intentional legislative favoring of a partisan purpose. So it's not directed.
In fairness, Mr. Dellenberg,
I'm sorry.
in relation to Justice Kennedy's question about whether there are any case law that deals with this legislative privilege, are you aware whether or not there are any other states in the country that have an amendment such as the one that's at issue here today that requires a look into this intent issue?
No, Your Honor. Florida stands out as the sole state in the United States.
So there shouldn't be any case law developing yet.
And there's not, you won't find case law in other states relating to a constitutional provision that prohibits wrongful intent.
So you're saying that
Florida is the only state that has such a provision.
Are you saying that there's no other state constitution that has a provision similar to the provision at issue here?
Your Honor, you have to tell me what similar means because there's
Well, I'll
state
just leave it
constitution.
at that. You're saying there is no such constitutional provision in any other state constitution?
There's no state constitutional provision that uses the word intent, Your Honor. There are other constitutions that use the word purpose, and I'm not.
That's a very significant distinction, I'm sure.
Well, Your Honor,
The distinction between intent and purpose.
well, Your Honor, the case law that's being cited here all relates to legislative
What's
intent.
the difference between intent and purpose?
Your Honor, there may not be any difference, but it's clear where the Constitution says there may not be an improper intent, we should be allowed to inquire into intent, all the facts relating to intent.
I am still concerned, though, if there should be some limitations on this. I could see real problems down the road if we allow just an unlimited deposition of a legislator or the legislative aid. And I'm wondering why you do not agree with the trial court that there at least should be, if there is some privilege or limited privilege, why there shouldn't be some kind of limitations on what you can and cannot ask a legislator. What is wrong with that proposition?
Your Honor, what's wrong with that kind of limitation is it denies us an opportunity to ask the questions, why? Why did you select one plan over another? Why did you draw the line here rather than there? We ought to be able to ask those why questions.
Even a question, that's such an open-ended question, it seems to me it's more appropriate to say, what was the objective evidence that you had to draw the line this place versus some other place? I just don't don't understand your argument of why this has to be an open-ended, let's do whatever we want to, let's ask anything we want to kind of question here.
Your Honor, we take the position that when intent is in the Constitution, we should be able to inquire into all the facts relating to intent. And by those facts include, why did you consult with outside political partisan political operatives in developing your plan? What kind of communications took place between you and outside political operatives? Was there a parallel secret process going on at the same time that there was an open apportionment process? And all those questions we think should be allowed.
Well, aren't those those are two different things. One would be objective. Was there another process? And then the prior question, what was your intention? Why did you do this?
Right.
I mean, that is exactly what is being described as the objective versus subjective, isn't it?
Your Honor, perhaps
You
so.
can find that out.
Perhaps so. I'm not sure at this stage, Justice Lewis. It seems to me that we ought to be able to ask the why question. Why was this done?
Well, maybe this is not a time for a absolute bright line. Maybe you're going to have depositions and objections to questions so that this can be defined. Is that what you're saying?
You know, Honor, I hope that this court will adopt a rule that allows inquiry into intent in the way we allow inquiry and intent where it's put at issue. And it's put an issue in this case by the Florida Constitution. So,
but you do see and respect this open-ended sort of request that's being made and the dangers that may pose for a valid legislative process.
Your Honor, it seems to me that if we go overboard and start doing a large number of depositions, the trial court is equipped to limit that. And also, in our inquiry, there's no reason that the petitioners in this case will want to extend the process of proceedings in the trial court because we've got a 2014 election coming on us.
But do you know, and I know you're in your rebuttal, but strikes me another reason why the why question would be not really, would be overly intrusive, it is subjective, is that the intent, if Andy Gardner, as personally says, sure, I wanted to have a district that would favor me, and that's why I picked this over that, but I thought they were both fine. Let's just say he says that. You've got how many members of the Senate? Wouldn't you, in order to show that in adopting the plan there was an intent to favor, need to take every senator's deposition to find that out? And that seems to be why you would stick to, if there were communications already developed, not why did you talk to this political operative, but you talked to the political operative the morning of this supposedly transparent public hearing you were having. And And that would be objective. Yes, you talked to them. Not why did you talk to them? It's pretty apparent if they were talking to political operatives at the same time they were holding public hearings, that a trial court or finding of fact could infer that they were trying to undermine the process. But isn't the problem the idea that the intent of the individual person, why, the why question, is within their own thought process and really isn't the answer just because one legislator would have wanted to do it this way or that way?
Your Honor, let's look at the legislative process as it operates today in Florida. On most issues, legislators are following leadership, and the people who make the determination are the presiding officers of the House and Senate and the committee chair. And in drawing a plan, a limited number of legislators were involved in drawing the plan. That's the constitutional word. You may not have wrongful intent in drawing a plan. And so we do not think a large numbers of legislators are involved. Your Honor, I'm deeply into my rebuttal, but Justice Perry had signaled.
My question has been asked and answered.
Good, thank you.
May it please the Court, Raul Cantero on behalf of the Florida Senate. Also with me is George Meros on behalf of the House, and I'll be doing the argument on behalf of all the respondents. We know now from the previous argument that there are no cases ever in the United States that have ordered the involuntary deposition of legislators to determine anything about the legislative process. And the ballot is...
As a part of that, are there any provisions, constitutional provisions in other states similar to the Florida provision concerning the intent of the legislators in drawing these districts?
Yes, there are. On page 30 to 31 of our brief, we cited, I think it's about 8 states that have adopted similar provisions. Now, I must say that all these adoptions are in the relatively recent past, so we don't have any cases really going either way on that issue. However, we do have cases going our way on issues regarding intent, regarding the Voting Rights Act, for example, in which intent is an issue. And many of the cases that they have cited involve the Voting Rights Act in which intent was an issue. And despite that, none of those cases ordered depositions of state legislators. In fact, the case on which Judge Lewis below relied heavily was Committee for a Fair and Balanced Map. Well, that case imposed restrictions on documents that were going to be produced and said there are certain documents you should produce, others are protected. It didn't even consider depositions. So Judge Lewis extrapolated from that and ordered depositions.
Let's go, though, to, you're candid, and we appreciate the candor that the states that have similar provisions have not had litigation over this. I agree that Judge Lewis's order, I can't accept the plaintiff's position that it's just should be, open-ended. And I think that in most cases of legislative intent, statutory construction, it would be improper to start to ask legislators, why did you pass this bill? But we are dealing with a unique provision that was adopted that didn't punish or prohibit effect, but intent. Now, the legislature in Apportionment 1 went out of its way to talk about the multiple public hearings that they had in obtaining public input. And so we have that in the record. Now, if at the same time as they were doing these hearings, there was a parallel secret process going on where they were really, because no maps were shown at those public hearings, where they were really developing the map they wanted, why wouldn't, and to me that's objective, why wouldn't that be directly relevant to refute what the legislature has already said, which is, no, we certainly didn't act impermissibly, because look at all these public hearings.
Your Honor, every single privilege that exists in the United States assumes that that privilege will protect against disclosure of relevant evidence. The attorney-client privilege would protect against disclosure of relevant evidence. It would be relevant if a defendant had told his lawyer, yeah, I did it. It would be relevant if a husband had told a spouse, yes, I did it.
Well, now we're
The
going
privilege
back
is designed to protect against relevant evidence, and I think...
But there isn't, and again, there's no evidentiary privilege. So now what we're really talking about, and I accept that it should exist, is a separation of powers issue and respect for a coordinate branch of government so that a legislator doesn't get hauled into court every time that a bill gets passed. But we're dealing with a once in every 10-year process and a unique constitutional provision. In that situation, it just seems to me that the need to effectuate the intent of the voters is served by the limited order that Judge Lewis entered that does protect against this wholesale, the why questions, but allows things that in the ordinary course of how this plan was developed for there to be some discovery on it.
Well, the order, although it seems to try to be fair, it has the same chilling effect as an order saying you can depose regarding anything, because legislators are still going to be reluctant to do anything to get involved in this redistricting process if it means now I'm going to get deposed.
Well, maybe next 10 years they won't, if there is evidence that it really wasn't quite as transparent as the legislature said it was, maybe 10 years from now it will all be transparent.
But that's not the point.
Well,
they're not going to take our word for it.
But the point is that we adopted and we approved the entire House plan and most of the Senate plan and reapproved the Senate plan, understanding that what had been presented showed indications that there was never an improper motive in how the lines were drawn.
We're not saying that they're not entitled to discovery. We've never said they're not entitled to discovery, even though they say that's what we've done. We have produced over 33,000 documents. The Public Records Act of the state of Florida circumscribes the legislative privilege so that anything that's a public record, they have gotten. The only thing that they don't have is depositions of legislators with which, despite the requirement of intent in other statutes and the Voting Rights Act and Equal Protection, have never been ordered in this country.
Let me ask you that about the documents, because I was trying to trace through where the protective order came. Is there a request to produce that is in the record that would show what it is that was the subject of the protective order? Because the only thing in the appendix to the petitioner's brief are the notice of taking depositions and the motion for protective order. I had to go back.
We've produced the vast majority of documents.
Well, are we talking about about that part of the judge's order? Is it premature to even address that, or are we talking about the draft legislative plans that led up to the final plan? Is that what? Because you talk about 30,000 documents.
It's true that they haven't requested, but they have requested all maps that were developed. The draft maps is the only thing that's exempted under the Public Records Act, and those are the only things that we have asserted a privilege.
Well, you understand, know that the case law is pretty clear that something that is exempt under the Public Records Act, which exempts something from the general public view, is those exemptions are governed then by the rules of discovery.
Yes.
So I don't understand.
Neither party in this case has contested that part of the first DCA's opinion, which says that it not only has to be exempt, it also has to be covered by the legislative privilege. So even though
what would be, but explain to me, are we talking about, because it's easier when, if we could have seen what the documents were that are at issue, and Judge Lewis had ordered the in-camera inspection, are we talking about draft plans before the final plan? Is that
yes, it's draft plans that were never filed to be considered.
Well, but what is,
in other words, there's plans going around.
And you're saying that's not we can't reach that because they have not cross-appealed that issue?
Well, we haven't cross-appealed. I'm not saying you can't reach it. I'm just saying that neither party has contested that part of the first DCA's opinion, which says just because it's exempt doesn't mean that you shouldn't produce it, and that Judge Lewis now has to conduct the analysis: A, is it exempt? And B, even if exempt, is it covered by the privilege or not?
But if we disagree with the First District's order about the that says it's a total privilege, wouldn't those draft plans would not be able to be produced? And so if we disagree with that part, we necessarily have to disagree with the part that applies.
Yes, well, if you find there's no privilege, then...
Well, I just don't understand how subjective, objective even would apply to draft plans. It might be that Andy
Maybe
Gardner...
some writing on a plan.
Yeah,
Yes,
so if it was a note
yes.
saying, I don't like this plan because...
Right.
Well, I don't like this plan because my house is here and I want it to be there. Is that would that be
Well, that's
subjective? Well,
that's
but was
subjective.
written in it's not in the brain. It went down and went back to the staffer.
A lot of things that are written in the brain are then communicated, and that's still subjective. I think that's subjective. You're thinking that's your opinion. That's
I think
still
I'd like to
subjective.
kill somebody. That's subjective.
You think that you killed?
Well, I mean, if I express it to another person.
Right. It may be, and you're pointing out the unworkability of a dichotomy between objective and subjective testimony, which is one of the reasons why the first DCA said, we're not going to accept that because it's just unworkable. You're still going to depose legislators, so there's still going to be a chilling effect.
Okay, so
there's still going to be a violation of the separation of powers.
I know you've thought about this a lot. So if you don't like Judge Lewis's order, but if the court decides there ought to be some discovery, how would you frame the appropriate? If you were writing the opinion?
I hate when I get questions like that. How would I frame it? I just don't think that deposing legislators at all complies with the separation of powers.
Okay, so
But
you
if
realize, but if we decide that it is not, it's a unique situation and it is a unique constitutional provision, and the other part I think Judge Lewis was worried about is that in defending this, a legislator gets on the stand and says, listen, I did this on the up and up. I had no improper intent. At that point, it's too late the discovery has been precluded. So how do you rebut that argument if, they've, quote, waived the privilege, but they don't do it until the time of trial?
Well, I think Judge Lewis in his order, and if not, we would concede that you can't waive the privilege without giving the other side an opportunity then to depose the person. And you can waive the privilege under Canon versus Davis from the Central District of California only for yourself. There's nothing that prevents a legislator from waiving the privilege. They can do that, but you can only do it as to your own statements. And I agree that we cannot claim legislative privilege during discovery and then at trial present a slew of legislators about what was intended. We don't intend to do that, and we shouldn't be able to do that. If we do intend to waive the privilege, they should have prior notice and they should be able to depose those that are going to waive the privilege.
So you can't come up with a
I would
better
say
construct?
If I had to, if you're pressing me on what the nature of the depositions would be, it would be any communications had with somebody outside of the legislature and not with other legislators, which is covered by the privilege, like an attorney-client privilege of communications with other legislators. It would be communications outside.
Could you just, the 30,000 documents, as a lawyer, in a products liability case, somebody might produce 30,000 documents and not one of them was, it was a lot of documents, but it was...
They included maps, they included 16,000 emails going between legislators and staff.
Okay, so now how did that communications...
It's a public record. And so we produce public records.
So if the communication between the legislator and the staff is there, but is something in the email that is unclear, you saying again that you couldn't ask the
I'm saying you can't ask in depositions because the legislators going in understand that they are subject to the Public Records Act and that Public Records Act circumscribes the legislative privilege.
See, I guess I thought when they were going into, and I remember what Will Weatherford said at the time, not to, but in the public record, that this was a unique time and they were going to take care take extraordinary care to have the redistricting process fulfill the intent of the voters, and so it was going to be unique and different. So the idea that the legislators went in there saying, we're going to say that, but at the same time we're going to do something else, I would be surprised that that's happening.
I think you're assuming facts, not in evidence. Just
No,
because
they
we're
were
saying
in-
this is going to be the most open process in history doesn't mean that we can't assert a privilege and against testifying in court and being deposed. Those are two different things.
Let me see if I can get a few questions in. Look, looking at it from a trial judge's standpoint, looking at it as to how workable this would be, it seems to me like when you have a deposition of a legislator, there's going to be an objection. It's going to be an objection to just about every question based on the fact that it's subjective. And then, because it is a privilege, the person doesn't have to answer it, and that question will have to go back to the trial judge, and you have to have a hearing on each single objection. I just see it as an unworkable situation for a trial judge. It would take days to handle each and every one of the objections that are going to be raised. And that's my concern about this issue here. I just don't, you mentioned, perhaps this is a better question for Mr. Dellenberg, and I hope he'll answer when he gets back. How is it going to be workable?
That was our position in the first district, and that's what the first district concluded, is that just the fact of having to be deposed, it's going to be an hours-long depositions. We don't even know how many they're going to depose. We don't know which questions are going to be determined to be subjective, which are going to be determined to be objective, and just the fact that that's going to happen is now going to have a chilling effect in the legislature. The way I see it, I'm sorry, Justice Lewis, did you have a question?
And I'm going to listen to the rest of your statement, then I'm going to ask you.
All right, I'll get ready. The way I see it, the privilege is based on three pillars. And the cases don't analyze it this way, but I think that's the way that you can see the cases. The first pillar is the privilege aspect of communications among legislators, just like attorney-client privilege or spousal privilege. The second is the respect for a coordinate branch of government, which is regardless of communications, we're not going to hail you into a deposition or into court to ask you questions about how you did your job, just like we don't ask judges about how they did their job. That's a separation of powers issue. And the third pillar, if you will, is the marginal relevance of taking depositions of individual legislators is not going to get you anywhere in determining the legislature's intent in drafting a statute or drafting maps.
But you would agree that the privilege is to the particular question that's being proposed.
Not in this instance, Your Honor.
You mean just a blanket then? I mean, you're asserting that an absolute blanket, you cannot take a deposition of a legislative member.
Regarding the legislative process, yes.
Well, again, I didn't say legislative process. You cannot take a deposition of a legislator because you did say if you're producing the statement, a message to someone outside the legislature. Is that part of the process or is it not?
I think it is part of the process, Your Honor.
Well, then, okay. Then
I
you're
was
saying you
answering
can
the
have...
question only because Justice Pariente made me answer it, which is if we determine there has to be some kind of deposition, what are the parameters of that deposition?
Okay. Well, so, I mean, anything at all that deals with their position is prohibited.
Yes.
Prohibited ground. That's your position on this.
Yes.
But it seems to me is that other privileges don't fall into that category. I mean, there are certain privileges, lawyer-client privileges, husband-wife privileges, that they are not absolute. I mean, they are circumspect by the terms of what's going on. Right. And I'm not sure that we have any just absolute blanket, even judges.
Well, Your Honor, that's why I talked about the three pillars, because it's not only based on the communication type of privilege, it's based on separation of powers. That's why you don't have any court in the country, if it were as you suggest, then there would be some cases, right, somewhere that say, yeah, you can depose a legislator for this, but not for that, for objective, but not subjective. No court has ever drawn that distinction because this privilege is more than just the attorney-client communication privilege.
Well, is this the only absolute privilege known to our jurisprudence?
No, and the judicial privilege as well. And
you can't ask judges certain questions about extrajudicial functions?
And that's why I said within the legislative function.
Behavior outside of the courtroom.
Yes, and legislators too. Yeah, I'm not saying
Okay,
it's
so, all
absolute
right.
in that sense. No,
Okay, well.
I'm not going that far.
Okay.
And just like if in the court in Girardeau said, if there's a criminal investigation, then that circumscribes the privilege as well, and we can ask questions to legislators about that. So I'm not going to the other extreme as well. But as far as the legislative function, especially in this case in drafting maps, in drafting a statute, that's all part of their legislative function. You can't ask any questions about that, and the mere fact of having to depose them, I suggest, is then a violation of the separation of powers, is then a not respect for a coordinate branch of government. And like I said before, why are we going through this exercise anyway if the intent that we're talking about is the intent of the legislature as a whole,
Well,
and not
because
of individual?
Yeah, I just want, the judge's order, because I go back to that and I read it and I reread it, he says that there are some categories of information and communications that are most in need of the protection offered by the privilege and some less in need. The thought processes of a legislature or the communication between legislators or between legislators and their staff fall within the first category. He says that.
Right.
Okay? And the second category would include routine transmittal communications between legislators and staff and communications with outside consultants or constituents. So although he talks, I don't find that all that difficult
Well, Your Honor,
to
but now
understand.
that assumes that now we're going to have depositions. And how many
I
legislators are we
understand that,
going
but I
to
guess you were
depose?
saying it was unworkable, and I just didn't think
It's
that.
just like saying, well, we're not going to call a judge in to determine how he decided a case, but we're going to ask him how many times he talked to his law clerk and what his law clerk did.
Well,
That's
if it was the next
objective
part,
information.
that would be, again, now we're really going outside of what the constitutional amendment called for and why this inquiry is relevant. But I appreciate your advocacy and your argument.
Okay, Your Honor, unless the court has any further questions.
Thank you for your arguments.
Thank you.
Rebuttal?
Thank you, Your Honor. If there's time, I'd like to make about 3 points. First of all, on privilege. Even respondents do not assert that the privilege is absolute. They concede that in some circumstances, that is, criminal law inquiry, the legislative privilege does not exist. They cite Girardeau, and it's clear that there are some things that will trump the legislative privilege. It's our submission that where you have a constitutional provision that prohibits certain types of criminal intent, of legislative intent, that is partisan intent, intent to intrude on minorities, you may also inquire of legislators. The second point I'd like to make is the point that was made by Justice Pariente about separation of powers. Let's think about separation of powers. We have a constitutional amendment. The duty of the legislature is to abide by the provisions of the Constitution. And the judicial role is to interpret that constitutional provision and to apply it in a way that it has meaning. And that includes allowing information about the process as it took place. The third point I wanted to make was a point about chilling effect. Counsel argues that there be a chilling effect. The constitutional amendments adopted in 2010 were intended to chill the legislature. It changed what legislature could do. The legislature could no longer do what it did in 2002 and adopt a plan with the intention of favoring a partisan party. Those types of intention were declared to be unconstitutional in 2002, in 2010. And we respectfully submit that to implement these constitutional provisions, you have to allow inquiry, including inquiry of legislators. Thank you very much, Your Honor.
Thank you for your arguments. Our next case for the day is Deborah Lafave versus State of Florida.
Good job. Oh, good to be with you.
You may proceed.
May it please the court. I'm Julius Alicio. I represent Deborah Lafave, the petitioner in this case. We're here on a certified question from the Second District Court of Appeal. Essentially, it's a question of whether the state may seek review by a petition of writ of certiorari a trial court's order early terminating probation. Back in 2005, Ms. Lafave entered a negotiated plea with the state, and she entered a guilty plea to 2 counts of lewd or lascivious battery. Subsequent to the negotiated plea, she was placed on 3 years community control, followed by 7 years probation.
And the negotiated plea basically said that instead of going to prison for it was lewd and lascivious molestation of a 14-year-old,
Yes.
that she would get community control and probation with the condition that she would not seek early termination of her probation. This is what the negotiated plea was, correct?
Well, that's not the exact language of the language that the negotiated plea has said that she could not seek to have her community control converted to probation until she successfully completed at least 2 years of community control.
So you're telling us that it was not you will not seek early termination of your probation?
Well, I'm not finished yet.
Oh, okay.
But the part of the probation, it said your client will not be allowed early termination of probation. So the plea agreement, it was very specific language that...
But wouldn't you concede that that statement implies that the client, if she's not going to be allowed it, it would imply that the client could not seek it?
Certainly. It does imply that. However, there is case law that says when dealing with negotiated pleas, the government is certainly in a superior position than the client or the defendant, and that the government is held to a higher responsibility for any ambiguities or imprecisions.
Well, but the fact that it unambiguously implies that. The fact that it's implied doesn't mean that it's ambiguous. I mean, you can't read that and come to the conclusion that notwithstanding that, she would be permitted to seek such early termination of probation. Can you?
Why not? It doesn't specifically say, well, maybe standing alone, no, but you have to compare it to the first part of the plea agreement where the plea agreement said that, it specifically set out she could not seek to have her community control converted to probation until she completed 2 years of probation. If the state wanted to bind her from seeking termination of probation, they could have easily said it because they said it in the part about community control.
We have to assume for purposes of here that she did contravene the agreement, because if the second district is wrong on the merits, that's one thing. But if the question is the third district right in 2002 when it said you cannot use cert for a final order, or is the second district right that in certain circumstances you can? So I feels if you say no, the trial court was right because it didn't violate the plea agreement, then that's a non-issue. It's the issue of cert versus an appeal is not at issue. You understand what I'm saying?
Oh, no, I'm not.
All right. The question is, even if I thought we were assuming that the order clearly provided for that she couldn't seek early termination. So let's assume that it does clearly provide for it. Can the trial court still do what it did? And even if the trial court really can't, because the plea agreement is clear, there's still a remedy for the state?
No, I think that the trial court could early terminate probation.
No, I know you think that. What I'm saying, I thought the issue is there a remedy for the state, even if it's wrong, through cert? The 3rd District in 2002 said that legislator should consider amending the statute to provide for the state's right of appeal in this type of situation. The legislature didn't. So now we know there's no right of appeal. The question is, assuming there's a case that clearly provides you can't do something, and the judge does it, is there does the state have a right to seek a petition for writ of certiorari?
If there's a case that clearly provides a judge cannot do something, and if it's an interlocutory pre-trial order, then yes, they can seek.
No, we're talking about, this is a final order, right?
The petitioner contends it is a final order. That, and I mean, that's part of the...
But I mean, it seems to me that this case is in a posture where everyone has agreed that this is a final order, so we're going to assume here this is a final order. Because the state sought cert, I would assume they believe they had no right to appeal because it was a final order. And it doesn't fall under any of those categories of when the state can appeal on a final order. Okay, so if we assume that, then let's get to the issue. As Justice Pariente said, the issue here is, does the state in this final order have a right to seek cert? If you say they don't, why don't they? Is this a departure from the essential requirements of the law, or is that even come into play at the point of whether or not the court has jurisdiction?
It doesn't come into play whether it's a departure from the essential requirements of the law, because State v. Pettis says that you cannot use a petition for writ of cert for a final order. It's clear. There's certain situations where there is no remedy from a trial court's decision. A trial court in certain instances is the court of last resort. For instance, on a motion for judgment of acquittal before verdict. The trial court enters a motion for judgment of acquittal, there is no remedy to the state.
But that's because of the double jeopardy protection. Isn't that correct?
Yes.
Okay. So we've got a category of things like that. This is not one of those. This has got nothing to do with double jeopardy here. Is that correct?
I disagree. I mean, at the probation, she served community control, probation. She successfully completed up to that point. Once the trial judge enters the order of termination of probation, jeopardy has attached. The case is complete. There's no further action to be done in the case. So it's over.
And that, you would argue, that's only so because there's no right of appeal with respect that the state has with respect to that. If the state had a right of appeal with respect to a decision such as that, would double jeopardy apply? Would preclude the appeal?
Yes, that rule might violate constitutional provisions against double jeopardy, because once a case is complete, you can't come back and do any more. The judge doesn't.
But they can appeal what the statute refers to as sentences that are illegal, right? And that's not subject to, if a court, for instance, fails to impose a mandatory minimum that's required, that can be appealed, can't it?
I don't.
Without violating double jeopardy.
I don't think so. I think there's some cases that, I'm not positive about that, but I think there's some cases, as long as it's not an illegal sentence, it cannot be appealed. The state has a right to to appeal an illegal sentence. But if it's not illegal, then they don't have that right to appeal.
Isn't the issue here, the legislature has granted the right of appeal to the state in certain categories of final orders. And we have, in recognition of that, said, no, we can't create other appealable final orders. In pretrial, cert's available. So again, I think, but if they decided, if tomorrow the legislature said, this Lafave case is a good example of something we don't think should happen, that is, once there's a clear plea agreement, the judge ought not to be able to vary the terms by terminating probation early. And I realize you say they still have that inherent right. You're not saying that if that appeal was created by statute, that it would be unconstitutional because it would violate double jeopardy?
It's possible. I mean, that's...
Well, but mandatory downward departures, I think that in the last 10 years or so, the state can appeal downward departures, I believe. Or I know they can get relief if the judge downwardly departs. There's no relief on the other side, but there is relief. So the legislature has expressed this intent to not allow judges to go below something that they've set forth. So I don't see how it would be a constitutional violation to allow an appeal or to allow cert if we otherwise had the policy of if Pettis or the third district don't stand for the same proposition. So, I mean, your argument here sort of, to me, has to be the court has set a policy in Pettis, as the third district has stated in its case, that cert should not be used for final orders. I mean, that's the rule of law.
Right.
And then my question really is, why, in a situation like this, if we find that the court clearly violated the plea agreement of the parties, why shouldn't we allow review by cert? I mean, you're saying, let's assume no double jeopardy. Isn't the harm to allow a defendant to get around a negotiated plea agreement is really, and so for the courts to sanction it, would be bad public policy?
Well, there is no authority for the state to negotiate away the third party who is the judge, the trial judge, to negotiate away the judge's statutory authority to early
the trial
terminate
court
probation.
the trial court accepted the plea. Now, there's no suggestion here that there was a problem in the process that was followed. This contract associated with the plea agreement was something that was before the trial court. The trial court accepted. If the trial court did not like this particular provision, the trial court, I think, could have said, I'm not accepting this. Isn't that correct?
I'm sure the trial court could have rejected it.
But the trial court did not do that.
I don't think it was an issue at that point.
Well, I understand.
When they come in with
it might have been an issue for the state. That's why they put it in that agreement.
Right, but there's case they knew or should have known that they cannot bind the trial court because that infringes on the trial court's jurisdiction over the supervisory capacity over probation. The trial court always has jurisdiction over probation. That's why probation is a withhold of imposition of sentence. It's
in
not.
In what case do you say that the state should have been aware that they couldn't put that provision in?
Marcinic holds that you can't, or Baker was a case that said that you can't prevent a judge from a future circuit court judge from early terminating probation. And there's the Arizona case, the State v. Patel.
And under what circumstances was that case?
The Baker case, Baker was the trial judge imposed a condition of probation and no early termination of probation.
But then you said the trial court, that was the trial court's deal with them? It wasn't the state's separate contract, as the plea agreement is with the state.
Right, that was not a plea agreement situation. The Arizona case, State v. Patel, was a plea agreement situation where they said,
Let me ask you, you mentioned earlier that for the court legal sentence, they can appeal, such as going underneath the guidelines for illegal purpose is not allowed. They can appeal that. You mentioned that.
well, there's a specific provision where they can appeal under guideline sentence. That's not necessarily an illegal
But an
sentence.
illegal sentence, the state can appeal that.
Right,
There's no double jeopardy problem.
right. Because basically the sentence is void ab initio.
There are statutes basically that do not allow probation in cases, aren't there? I mean, manslaughter, I think.
Sure, for
Things like that.
first-degree murder.
So if a court were to sentence someone convicted of first-degree murder to probation, that could be appealed because that's an illegal sentence.
Correct.
You know, in this particular case, the parties entered into a contract. Would you agree that a plea agreement is a contract between the state and the defense?
Yes,
And the contract provided that there will be no early termination of probation.
yes.
Okay? The court clearly violated that contract, didn't he?
No, the contract was between the state and the defendant,
Right.
which cannot bind the trial court.
Okay, that's your position.
Yes,
But under that position, then the state and the defense can agree to an illegal sentence. And the court has nothing to do with it. Probation, for example, in a first-degree murder case.
no, they can't agree to an illegal sentence.
I mean, it just gets tricky with me. And I think what you're asking us to do is to write an opinion that basically says that the state and the defense can agree in a negotiated plea to no early termination of probation. And that's going to be not enforceable.
No, it could be enforceable if they specifically said the defendant could not seek early termination of probation.
Isn't that what the defendant said here?
And no, it said will not be allowed early termination of probation.
But if you take your argument to the extreme, it seems to me it doesn't matter whether it's the state, whether the language says they won't seek it, or that you shouldn't have it. If your argument that the trial court always retains the right to early terminate, no matter what the agreement says, then it doesn't matter whether she actually agreed or the language was somewhat ambiguous. That's your argument, really, isn't it?
If you make it a violation of the condition of probation, then she wouldn't be able to seek early termination if you made that part of the plea agreement.
If you made it what?
Part of the plea agreement. That
So under those circumstances, the trial judge, under the statute that you reference, it doesn't have any authority to terminate probation.
the
You
trial judge
said
always has
your
authority to
argument
terminate.
earlier was that the trial judge always has the right to terminate probation early, correct?
Right.
So it doesn't matter what the language of the agreement is.
No, because even if Ms. Lafave did not seek to early terminate probation, the judge could have done it on his own.
That's exactly what I'm asking you.
Yes. I would like to save the remainder of my time for rebuttal.
May it please the court. Excuse me. I'm Cerise Taylor and I represent the state of Florida. There is no authority that prohibits a defendant from contracting away the right to early termination of a probationary sentence.
Aren't we here on the question of whether you can take, whether certiorari is appropriate, not really the validity of the underlying plea?
Yes, Your
And
Honor.
it seems to me that you all are arguing a different case than the court thinks it's hearing. So I think you all need to address the fundamental principle, and that is the line of cases from this court and others that says that if you cannot take an appeal from the order, a final order, that you cannot take a petition for cert will
Absolutely,
not lie.
Your Honor.
Isn't that what we're here about?
Absolutely, Your Honor. That is
Could you address that in that line of cases?
Yes.
That seems to be contrary to your position in this case.
Yes, Your Honor.
Correct? I mean, am I misunderstanding what the law is or anything while we're here?
No, that
Okay.
that is the question of great public importance that is presented
Okay.
to this court. When you have a post-sentencing conflict regarding a negotiated plea, there needs to be a remedy. The state's position is that that remedy is certiorari because the rules do not permit an appeal of a situation like this. Without that remedy, the state has no ability, no redress.
Ms. Taylor,
Yes.
isn't that what the the first district in 2001 expressly confronted? They said the state's right of appeal in a criminal case is not a matter of right and is available only as provided by statute.
Yes.
You agree with that?
Agreed.
Okay. They then said, and there were concurrences by Judge Sharondo at that point, saying, this is one of these cases we've sort of urged the legislature to create that narrow additional appellate remedy. And the state over the years has certainly not been shy to seek to enhance its ability to do it. So my concern is that seems like a pretty simple rule to enforce. No cert if it's a final order, cert if it's non-final order. I am in one way offended by what happened here, but on the other hand, there is 92405 that seems to give the judge inherent authority to terminate probation early.
In an effort to address both of your questions.
So going back to, going back to the question, it seems that aren't we here to decide whether the third district was correct back in 2001 in setting forth the rule that no final appeal, no cert?
What we're here to do, Your Honor, is to clarify the evolution that Pettis represents with regard to the ability of the question of appeal to be addressed. What we're talking about, appeal arises when there is a final order that needs to be appealed, and right now the state is not permitted to appeal in these situations. Pettis talks about the viability of certiorari as a mechanism to address gross miscarriages of justice. Appeal has to do with errors in the law. Cert has to do with miscarriages of justice that affect the fair administration of justice. Pettis represents an evolution that began in Jones, where Jones first said, if you don't have a right to appeal, you don't have a right to certiorari. And then Justice Boyd steps forward in his concurrence and says, let's be clear what we're talking about here.
Wait a minute, concurrence is nothing.
I recognize that it is not binding, but it does represent, and it also is repeated again a second time, the thought process behind that statement, because that statement of no appeal, no certiorari, taken literally, would foreclose the availability of certiorari, and even Pettis doesn't do that. What Pettis says is, wait a minute, Jones, no appeal, no certiorari, that's too narrow. We're going to take it back a step, and we're going to say, yes, state, you do have a right to certiorari in non-final orders.
Well, that gives the right to seek review in every case then.
No,
Every
Your Honor.
case. It does. You're saying don't go back. It's too broad there. Well, certainly what you're suggesting is just as broad in the other direction.
With all due respect, Your Honor, what I'm suggesting, the remedy that we're seeking in this case is a recognition under Pettis that disputes about post-sentence disputes, conflicts about plea agreements, negotiated plea agreements, fall within the parameters of Pettis. What we're saying is these are not, and with all due respect to the court, I understand why this looks like a final order, and it maybe even was intended to be a final order, but to accord it finality status would to prevent the state from having any basis to address a miscarriage of justice.
But the legislature, in deciding which categories of orders, final orders, should be appealed, makes the determination from the most compelling reason to the least compelling, and they have a narrow set. You're saying this is so compelling. If it's so compelling, there ought to be a right of appeal. And I'm not sure if we adopt the reasoning of the third district, you're out of luck in this case. Is that correct? Yes?
Yes.
Okay.
The Jordan case?
Is that the third district?
But Jordan is factually distinguishable.
It seems to me that they are really kind of parallel cases, because if I recall Jordan, that was a failure to do some substantial assistance, right? And so the sentence that the defendant was going to get was based on the agreement that he, another sort of contract, that he would provide substantial assistance. And when he did not do the substantial assistance, the trial judge gave him the sentence anyway. Right. Correct? Right. And so how do you actually get around that case? It seems very similar to me to this situation. And keeping in mind that Pettis was decided in 1988, and this is a 2001, Jordan is a 2001 case.
Your Honors present a couple of things I want to address. First of all, I cannot express enough that we're not talking about the right of appeal, although it would be nice to see an evolution of the right of appeal for the state to reflect the situation.
I understand, but Jordan says there was no right to appeal, and it says there was no right for the state to seek cert.
Do you not agree that, this court has no power to create a right of appeal from final orders?
Absolutely, and that is why.
So I'm at a loss because you're arguing that's what ought to happen in this case.
What I'm attempting to do, Your Honor, and maybe not as successfully as I would like, so let me be clear. I'm trying to address Justice Pariente's concern about whether or not we are seeking an evolution in the legislative branch and having an appeal right established. And that's not what we're doing. What I'm trying to do, Justice Lewis, is address what you've asked about, which is Pettis, and whether Pettis covers the circumstances in this case. We're not looking for, in Jordan, Your Honor, the state had not given its full measure of its consideration, and the defendant had not received the full measure of its consideration, and we were at a sort of a sentencing stage. This is a post-sentencing. There's a reason that the Second District called this a rare post-sentencing order, because this is not the kind of thing that Pettis could contemplate. The case is essentially done, but there is still the supervisory position that the trial court holds, and at that time, you have one party to the agreement, the petitioner in this case, failing to abide by the negotiated terms. These were favorable, beyond favorable negotiated terms to which the petitioner received the entire benefit. At the end of the day, when the state was still entitled to its consideration under the agreement, the state was barred from asserting that. And that is a departure from the essential requirements of the law, which Pettis recognizes retains its viability, despite the fact that there is no appellate right, because of the fact that there is no appellate right. And that is why Justice Boyd cautioned against reading Pettis to say that no appeal is no certiorari, because if there is a departure from the essential requirements of the law, the district courts of appeal, in their supervisory capacity, must retain the power to reach down and correct it.
If we allow that in this case, where do we draw the line?
Okay.
Wait a minute.
Sorry.
It seems to me it's a pretty clear line right now that certiorari is available for non-final orders. Mm-hmm. Okay. And let's assume we're taking, for the sake of this argument, that this is a final order.
Okay.
I could envision any kind of final order coming down in the state saying, "Oh, this was so disastrous. We really need to bring this issue to the court's attention," and we're opening up certiorari to a whole line of other kinds of issues.
I understand what you're saying, Your Honor. I understand that concern. Two things. One, certiorari is self-limiting by its own creation. It is not addressing errors. It is addressing miscarriages of justice, departures from the law by a judicial officer. So certiorari takes care of itself in limiting itself. Secondarily, how the state fashions this remedy is to consider it in this way. When you have a post-sentencing conflict regarding the negotiated plea and its application, in that limited, narrow circumstance, certiorari would lie to permit the state review. The result, if we do not have an avenue of review, as this court has already recognized, is individuals finding themselves not bound by the agreements that they entered into, willingly, knowingly, negotiated, received substantial benefits for. If that is allowed to occur, the state would have no incentive to participate in the plea process. What incentive does the state have to participate? What incentives anybody
This
have?
has only been going on for 20 years. Why doesn't the legislature, the state, change it if it's wrong?
Your Honor, perhaps because this case is before the highest court in the state, some action will be taken. However, we cannot wait for the legislature to act to address miscarriages of justice in the cert context. That is the duty of the court to
Let me
evaluate.
ask you a question about how awful this is. You do have 948.05 that gives, it would appear, the court, I mean, it does give the court authority to either on probation, because it's supervisory, to be either admonished or commended, and when satisfied that the action will be for the best interest of justice and the welfare of society, it may discharge the probationer or offender from further supervision. The state doesn't make an argument that Ms. Lafave was actually, but for the provision that she didn't deserve to be terminated from probation and eliminate the cost to the state from continuing to supervise her. This occurred in 2000, and the second district case is 2011. We're in 2013. Was this order stayed? I mean, did she complete her probation then, or what happened? Is she?
She is presently serving probation.
So she's actually because of something else?
Because of the second district's order.
Okay, so in terms of this, if we are to quash the second district, in this particular case, the state got the remedy of that she stayed on probation. And I'm not, I just that when you talk about something being super awful, terrible miscarriage of justice, just want to bring it down to what we're talking about here. And it just seems to, so she's, and she should have, does she have more years of probation?
Yes, I don't know exactly the number, but there are more.
Had was there ever any evidence that she had violated the probation?
There was
a
not substantial willful violation.
Okay, so going back to this, I'm just still not sure, and following up on Justice Quince's question, why the better policy isn't to say that the state has a right to appeal when the trial court enters a final order that is at variance with the plea agreement. End of the story. I mean, and the bottom line is I would imagine in the future the state will take measure when they're seeking the approval of the trial court to make sure the trial court is, not only accepting the plea, but accepting the specifics of what they can and can't do. I mean, you're just predicting all these horrible things happening, and I'm just not sure that that's the case.
With all due respect, Your Honor, the sides of the bench are concerned with parallel questions, the applicability of Pettis, and the sort of nuts and bolts of this case. I don't mean to suggest that that's not really true. I do mean to suggest that the impact of this case is far-reaching. With regard to whether or not she complied with specific elements of her probation, that really isn't why we're here. That is really a question for the trial court if 948.05 were to apply. And I need to talk about what you said about in the future when we engage in plea agreements, we would seek to bind the judge or that kind of thing. What Justice Quinn said earlier is absolutely right. No matter what language we use, if you give the petitioners their argument, there is no way for us to obtain relief. 948.05 says you can obtain early release from your early termination of your probation if it's in the best interest of society's welfare. That is something that the trial judge can engage in sua sponte. That's not what happened in this case. And the petitioner in this case contracted away her ability to obtain that right, her allowance.
Why would you say that? I mean, the trial judge did not apply that standard, whether it was in the best interest of everyone, to continue probation? What standard did the trial judge use? I like the defendant, so I'm going to let I'm going to terminate.
The reason I say that, Your Honor, what the trial court said is that she complied largely. She did what she was supposed to do. But what she did not do was serve the entire probationary term. And our position is that it is not in the best interest of society to allow someone who's on sexual offender probation, which is a specific type of probation intended to consider the person, to monitor them carefully for the entire supervisory period. It is not in our best interest to let someone on sexual offender probation off early. And when you look at not only the plea, but the judgment and sentence itself, signed by the court, says no early termination. The intent always, from all the parties, was a 10-year supervisory sentence. And it is a miscarriage of justice in any form when a trial court does not abide by the terms that the parties have agreed to, when they disregard the law of contracts, the law of agreements, and assert an authority that they do not have. And that is what happened in this case. And any kind of extrajudicial, ultra-vires action by a trial court is a departure from the essential requirements of the law.
Well, then, I mean, pleas are agreements.
Absolutely, Your Honor.
So every plea case is now going to be open to assert if it's changed by the trial judge under the statute.
No, Your Honor.
Well, why not? I mean, you're saying that this is a class of cases. Every one of them, I mean, you may dislike this one more because of whatever the underlying facts were than the next one that comes along, but you're giving that remedy in every plea case.
I'm asking for this court to fashion a narrow remedy that reflects the posture in this case, that it is not just all plea negotiations, it is post-sentencing. It is a conflict in the plea agreement like the conflict in this case.
Well, you were arguing that they agreed to it, so I mean, which is it? You know, every time it's like Jell-O. I ask a question and it changes. You were arguing that because the defendant agreed to this, that it's contrary to the essential requirements of the law, that not be fulfilled. That's a plea agreement. That's what you were arguing when I asked the question. So I'm saying is, if on that argument, I mean, we would open up the possibility of cert in every plea agreement that the state doesn't like. Well, that's virtually all of them, because if they wanted to do it, they would agree with it.
No, Your Honor, what we're trying to get at here is the relief that the state is accorded when there's a violation of the plea agreement in this sentencing context. We're not trying to, and this is what Pettis has as its concern, is the state trying to obtain that which it is not entitled to, greater rights than it is entitled to. And that's not what we're trying to do here. What we're trying to do is seek from this court a remedy. When we engage in good faith negotiation, we deliver up good and substantial consideration, and then the terms of the agreement are ignored. And we are barred from review of that.
Then what you're saying is that we need to take out a pencil and erase the statute under which the trial judge operated in this case.
No,
because
Your Honor.
That's specifically, isn't it? Is that statute specifically designed to be applied in cases where there's a plea? I thought that's what that did.
It is absolutely applicable unless you contract away the right
That's
to
what
its
a plea
application.
is, though. A plea is you've contracted
Yes,
in a plea.
that's what I'm saying. I am trying to say that the defendant in this case, the petitioner in this court, had that availability, the potential. I mean, it's a potential availability. It's not a guarantee. And in exchange for not having a 30-year prison sentence, she took as a consideration and gave as a consideration that she would not seek early termination of her supervisory sentence. We're not trying to bind the DOC. We're not trying to bind the trial court. The trial court could act. She could not accept the benefit of that action.
So if the trial court could have, after the second district case, sua sponte done what it did, but without Ms. Lafave seeking it, is that what you're saying?
Yes, except she would not have.
I mean, I guess it feels like form over substance. But
No, because she couldn't have accepted the benefit of it. We're not trying to bind the trial court. We're trying to say she could never accept the benefit of any early termination. She agreed. She is bound. That's what we're talking about here. If you contract away a right, the fact that somebody can convey that to you and you can't accept it, that's the difference here. We're not trying to bind the trial courts. We cannot. I cannot in good faith argue that to this court. But what I can say is that the law of contracts, the law of agreements.
But it seems to me that that's the only way that really works, is that the trial court cannot also violate the plea agreement, because otherwise it doesn't make sense for you to argue, at least to me it doesn't make sense, that The trial judge can do it, but she can't accept it. If the trial judge enters an order that says she's not on probation anymore, then she's not on probation anymore. And so to argue that she can't accept it, it just doesn't resonate. It just doesn't make sense.
Well, let me attempt to clarify.
That in these circumstances, you cannot, no one can do it.
What happens when the
Otherwise, it
trial
makes no
court
sense.
acts in this case? We're not trying to bind them, but what happens when the trial court acts in this case? It ratifies the breach of the agreement. That is a departure we're talking about here, not allowing early termination. It is the ratification, the act of allowing her to make this argument from the time that the motion to early terminate is filed all the way through accepting the hearing instead of dismissing it, which is what the court should have done. It was an unauthorized motion, and the court should not have heard it. But allowing that to occur, that's a departure from the essential requirements of the law. The order in this case that terminates is a culmination, really, which grants their motion, what the order actually does. It culminates in the final act of departure from essential requirements of the law. But throughout, the court's allowing this to proceed, accepting this. That is the departure from the essential requirements of the law that we're talking about. That is the way in which this court ratifies a breach of the agreement that, while it is not a direct party to, because I don't believe that they can be direct parties to that. The law does exist that we cannot hold them to future trial courts to act under 94805. But what Judge Timmerman did when he signed that order, when he ratified the agreement between the parties, was to say that those parties are bound thereby. And allowing her to get early termination, to seek early termination, to have this petition before the court, departed from the essential requirements of the law because it ratified her breach of the agreement.
Thank you for your arguments.
Thank you, Your Honors.
Rebuttal. I'll give you an additional 2 minutes.
Thank you, Your Honor. I want to note in State v. Rutherford, which I know is not binding on this, it's an Arizona case. Interestingly, they say by plea agreement you can state a specific term of jail, but then it says any further attempt by prosecution to control conditions of probation would be an infringement on the court's jurisdiction over probationers. And that's essentially what happened here. Probation is not a sentence, it's a withhold of imposition of sentence so that the trial court can retain jurisdiction, because we can't foresee into the future, how the probationer is going to perform. I mean, to complete this community control, obviously the court was very impressed with this because very few people are successful. And
So should at some point, at the time of the plea agreement, should something have been said about not with the trial judge? Should the trial judge have said, well, I can accept this plea agreement, but under 9, whatever the number statute is, I have the ultimate authority about termination of probation. So, because is that provision of the plea agreement illegal? Is it unenforceable? I mean, what? Right.
I don't think it was really discussed, and the trial judge
we know
actually
it wasn't
indicated,
discussed, but should it have been discussed?
Probably, but the trial court, when he granted the early termination of probation, says, I'm not a party to the plea agreement. The plea agreement is between the state and the defendant, and I'm going to follow the statute, 94805, which allows me to early terminate probation. There was no discussion about the statute, and probably had the state told the judge, well, Judge, you're entitled by statute to early terminate probation, but this plea agreement is going to bind your hands, and we're not going to allow you to early terminate probation.
By statute, the judge would be entitled to impose a sentence of up to however many years it would be for these offenses to which she has entered a guilty plea. So the notion that the plea agreement can't somehow restrict what is otherwise within the authority of the trial court to do once a guilty plea has been entered seems to me to just be kind of nonsensical. What am I missing?
Well, the cases clearly hold that a plea agreement can control the incarcerative portion of a sentence.
I guess my point that I'm struggling with and I want to give you an opportunity to help me, is why is that different than what happened here? And why is that materially different?
Because
Different.
incarceration is a sentence, and it's complete once it's imposed. Probation is a withhold of imposition of sentence, and the court retains jurisdiction to modify or change that probation during the entire time of probation. And
Well, now, let me ask you on this. You say it's not the imposition of probation is not a sentence. What if there's a case where there's a mandatory minimum prison sentence, and the judge imposes probation instead? Clearly not consistent with the statutes. Is that appealable by the state?
yes, it's an illegal
Well,
sentence. If it's
But you just said probation's not a sentence. How can it be an illegal sentence? If what's been imposed is probation, and you say that's not a sentence.
because the court is required to impose jail time or prison time. So if the judge does not do that, then he's not following the law. It's appealable as an illegal sentence.
Thank you for your arguments.
Thank you, Your
The
Honor.
court will be in recess for 10 minutes.
Supreme Court of Florida is now in session. Please be seated.
Our next case for the day is the Florida Bar versus Lanell Williams-Yulee. You may proceed.
Thank you. May it please the court. My name is Ernest Myers. I represent the respondent, Lanell Williams-Yulee, who is here with me today on a grievance matter that was brought against her by the Florida Bar. We're here today to request this court depart from the referee's recommendation of finding of guilt and that this court enter an order of not guilty on for any violations of the rules regulating the Florida Bar or the Code of Judicial Ethics. The referee found two findings of guilt, one of which was that Ms. Williams-Yulee had signed a mass mailing letter in violation of Canon 7C1, and they also found that she made a misrepresentation allegedly to a reporter from the St. Pete Times.
Does she have a committee of responsible persons?
Yes, she did.
And so they did not send out a mass mailing letter. She did.
Not originally, Your Honor. Originally, the letter was drafted with the aid of the committee. Testimony indicated that Ms. Yulee created this with the aid of the committee, but she signed it herself. When it was brought to her attention that this was in violation of Canon 7C1, that letter was immediately withdrawn, and it was replaced by one that was published by the committee.
So she understood under the canons that you solicit funds through a committee. She understood that.
Well,
I mean, she formed a committee, so I assume that indicates some understanding that that's how you do these things.
Yes, Your Honor. I think when it occurred, because at the time of the election that they were at, which is that Ms. Yulee had filed for the seat and that no other judge or no other candidate had filed for it, she was aware of the canon. She reviewed the canon. When looking at the canon, which talked about that it applied to elections that are filled, seats that are filled by elections between competing candidates, at that time, she read that and she, quite honestly, misinterpreted that, saying, well, wait a minute, if there aren't competing candidates, this doesn't yet apply to me. And at
So
that
now we're going to take something where there was an honest misconstruction of a canon, and you're asking that we declare the entire canon unconstitutional as violative of Ms. Yulee's freedom of speech?
Well, Your Honor, the canon does appear to be unconstitutional as a violation of her freedom of speech, whether or not she was making that point at the time she made the mistake.
Well, are you asking that it be declared unconstitutional both as to in-person as well as, quote, mass mailings?
No, Your Honor. I believe that there are some legitimate restrictions that can be placed on a candidate's speech in a judicial context. The problem that we have here is that mass mailings, by their very nature, should not be prohibited by the canon.
What if the sitting judge sends a letter to he or she asks his campaign committee, I want to know every litigant that has appeared before me in the last 2 years, I want to send letters to them, and I'm going to send it personally. I mean, the whole idea is that it's bad enough that 90% of the public think that campaign contributions influence judges' rulings, because that's, or something high, maybe 80%. But the idea that and especially it's certainly with a sitting judge, we apply it, and you're not asking for a distinction to be made, having gone through a merit retention election, the distinction seems important one, which is your committee can do this, you can't. And, so the freedom of speech on that intrusion seems minimal. Where's the, I guess the question on the balancing and reading all of the opinions, it seems that, where do you stop? But you're saying mass mailing, and what would be a mass mailing? Something over, if it's not to the litigants that appear before you, then it would be okay if you send it to every member of the bar?
Well, I mean, again, I think that what you're discussing seems to more be a targeted mailing as opposed to what I would refer to as a mass mailing. I think what the case is referred to as a mass mailing, when you're talking about getting a list of all the members of the bar
in a
particular area.
I thought she sent it to people she knew.
Actually, there was no testimony with regard to exactly how many of these were sent out and to where, but I do believe they were sent out to members of the bar in Hillsborough County.
On the second issue was, refresh my recollection, Judge Greco is the position, correct?
That is correct.
And it's my recollection that under the facts that he was appointed to fill the term of an existing judge at one time?
I believe that is correct, Your Honor.
Was he then elected after that?
I don't know the answer to that. It's not in the record.
It seems to me, I mean, even in interpreting, all this whole discussion, that it may become important. There's one thing that somebody is, and maybe I'm wrong on my thinking, but it seems to me that there's a distinction between someone who's been appointed to fulfill a term and has not filed to keep that position, and whether that person is really an incumbent when you would compare with someone who has been on the bench 3 or 4 terms and they keep upping. So, see, me, is that not somewhat important in our looking at this? I mean, is that person considered an incumbent when they're appointed to finish a term? Because it's my recollection that that's what happened down there, but I don't know whether this was in his fulfilling one or coming up to be elected is what my factual, I don't know.
Yes, and Judge Lewis, I don't know if he was at that time had fulfilled a term and then had run for a term or not, but the issue really here is, was a misrepresentation made? Because,
well, I mean, it goes to it seems to me, it goes to how you characterize what he is.
Well,
so it is going directly to what your issue is. I mean, because my thought process is leaning me to say, one in that position is not incumbent and supports her position, that there was no incumbent in this position. You had somebody that would have been appointed to fulfill it, and it would be different. If that's not a point that you want to even talk about, I won't consider.
Well, I certainly, would like to talk about it. If in fact he was not considered an incumbent, then there could be no misrepresentation possible as a matter of law, because it couldn't have happened. The facts of this case, though, also indicate that whether or not there was a misrepresentation has to do 100% with a conversation that happened between Ms. Yulee and Ms. Jenkins, the reporter for the Times.
Let me ask you about a specific part of that conversation. Paper, and this is the subject of your brief. Now, the newspaper reported that the respondent here said it is an open seat, and that was a direct quote. Is that correct?
That's what the article indicates, yes, Your Honor.
Now, has the accuracy of that ever been challenged?
Well, I think that the testimony of Ms. Yulee during the final hearing...
Did she say that she did not say that?
No, she was never asked whether she had said that or whether she didn't say that. What she did testify to was that she had a conversation with Ms. Jenkins, that she specifically spoke with Ms. Jenkins as to the issue of Judge Greco, that she admitted that, yes, he is an incumbent by virtue of the fact that perhaps he actually has the seat at the time, but there is no incumbent in the race because he has not yet filed.
Okay, but no incumbent in the race, that's one thing. But the statement, it is an open seat, let me ask you specifically about that. When reference is made to an open seat, doesn't it refer to a seat where the incumbent has expired, like died? If someone had died and then there was going to be an election, that would be an open seat. Or if the incumbent has announced an intention to retire, that would be an open seat. Or if the incumbent was precluded by law from seeking re-election, that would be considered an open seat. But aren't those the circumstances that are referred to by the use of the term open seat?
You see, Your Honor, your question is exactly what the problem here is that we don't know what was being used, what the context of the phrase open seat was. If there is a judicial election where no one has yet filed any paperwork, that is, there are no candidates yet who have filed paperwork, can that also be considered it's an open seat for the purposes of the election? And without that context, in other words, was the term it's an open seat, did that mean it was an open seat because she is the only one who had actually filed paperwork to sit in that particular election?
Well, what you're saying is it's an open seat because there's the prospect that somebody might retire. Not that they've announced that they're going to retire, But because they've not announced that they're going to seek re-election or election, there's the prospect that they might retire, and therefore we call that an open seat.
What I'm saying is that the phrase open seat in that quote, in that article, is completely without context. It may mean exactly what you just said. It may mean something else. But the problem is that the bar, in this case, in order to discipline Yulee, has got to prove by clear and convincing evidence that she made a misrepresentation. By saying open seat, and we have a question, as you indicated, does it mean this or does it mean that?
Well, I asked the question. I don't think it's unclear. I think people who use that term understand that it means that there's a seat where I know no incumbent is running and is going to qualify, and that it is open in the sense that that I know there's not going to be an incumbent in this race, and that's different than a situation where the incumbent has simply not announced an intention.
Yes, the problem is that the evidence in the case and the testimony in the case showed that that was not the context of the conversation. And if, in fact, that wasn't the context of the conversation, and if the context was, as you may suspect that it was, then the bar had an obligation to put on some evidence of that.
What was the evidence of what was the context of the conversation?
The only evidence in the record of the context of the conversation is the testimony of Ms. Yulee.
And that was?
And that was that there was a discussion that Judge Greco currently held the seat, but he currently had not yet filed to run in the election. There was...
and that made it an open seat?
That was the context of the conversation. The phrase open seat was never discussed during any of the testimony, either by the bar or by Ms. Yulee.
Now I'm on.
There you go.
At the time that the statement was made, the incumbent had not yet filed papers.
No, and at the time the article was published, he had not, and in fact, solidly 2 months later, there's evidence in the record he still had not.
Had she said, as of today's date, it's an open seat, we wouldn't be here today.
That's absolutely right, and she claims, at least in her discussion, that that's what she said to Ms. Jenkins. But that isn't what showed up in the newspaper, and we don't know what Ms. Jenkins' side of this conversation is because the bar never put Ms. Jenkins on the stand.
But I guess I'm still going back where, I mean, not that a public reprimand, I realize that's something, but the bar's not seeking that she be suspended from the practice. In every part of this state, I think lawyers understand that what an open seat is what Justice Kennedy described it. That is, the incumbent is not running again, and that therefore there's going to be two non-judges or a circuit, maybe a county judge that are going to be competing for a particular seat. Is there something different in the area where you practice that would say, no, open seat has different meanings to different people? I mean, honestly.
No, I understand your question, Justice Parianti. The problem here is that there was a conversation between two people, and what they understood their conversation to be, there's only two people that can testify as to that. Now, Ms. Yulee testified as to what her understanding of that conversation was and the point she was trying to get across to Ms. Jenkins. Now, did Ms. Jenkins not understand what she was saying? Did Ms. Jenkins misreport what she was saying? Or did Ms. Jenkins perhaps have bias? There's evidence in the record that Ms. Jenkins was biased against Ms. Yulee. So all of these questions are there, and again, we come back to before the Florida...
the reporter, if, in the circumstances we have here, if the reporter is told this is an open seat, and the reporter knows the facts, I can understand why the reporter might think, you're trying to pull the wool over my eyes? Why are you telling me it's an open seat when I know that there's an incumbent and I know that the incumbent has not announced an intention to retire?
Well, I think, though, the problem, though, that we have here is you're trying to read into what Ms. Jenkins was thinking and, more importantly, what Ms. Jenkins was told based solely on what she put in the article. But again, you've not contested that this statement, it is an open seat, was uttered. Well, but there is her testimony as to the context of the conversation with Ms. Jenkins, where she was saying that, basically that the seat is open because Judge Greco hadn't gone ahead and put in his paperwork, which he hadn't done. In other words, if there was no incumbent running, which is what she says and what she testified to, there is no incumbent in the race as of November 3rd. That is an absolutely 100% true statement. She can't be disciplined for making a misrepresentation for making that statement.
But when it was done the November before the March qualifying?
Yes.
So now you're saying that any lawyer could, even though there is no intention of the judge to retire, and most of the, in every community, they know which judges are going to, or which are term limited, not, out, that they can say anytime up till the date of filing, it's an open seat.
They can go ahead and say there is no incumbent in the race, which is what Ms. Yulee testified to that she said to the reporter.
To me, that's a sleight of hand, and that's, I think, what the bar, what the referee must have found, that it's not, it's sort of, it's by omission, it's incorrect, which is the problem. And I don't know that Ms. Yulee really, here's the issue, is was she trying to obtain an advantage by this, or what was the purpose of the discussion? Was the reporter asking, are there any incumbents in there?
Well, we see that's exactly what's going on here, is that if she's asked the question, if there's someone basically running against her, is there anyone else, is there an incumbent running for the seat? She can't, how can she answer the question, yes, there's an incumbent running for the seat when the incumbent hadn't filed paperwork to run for the seat? But you were telling me, again, 95% or more of judges who start in office, they don't announce each 6-year term, 6 months before. I want everyone to know running, unless you're in Miami-Dade, where everybody establishes their committee 2 years before. But, as a practical matter, judges, we don't even want judges to be thinking that way, to start campaigning months before if they're not going to have opposition. But it's not a good thing. But the question wasn't asked of her, is Judge Greco going to enter the race? The bar tried to ask that question of her at the hearing. Can you see the future? Do you know if he's going to enter the race? That isn't what the discussion was. The discussion was in November as to whether or not there was another candidate that was in the election. And at that time, there wasn't. He hadn't actually gone ahead and filed. And the fact that he was going to file or might have gone to file doesn't go to her answer to the question.
How long had the filing period been open?
I'm sorry?
How long had the filing period been open?
It had been open since at least September, because I know that's when Ms. Yulee had filed. So it had been open for at least 2 months. I see that I'm deeply into my rebuttal
What filing
time.
period are you talking about? I don't understand the filing period.
And when I think the question is, when could a candidate first go ahead and say, I would like to run for this seat?
You mean when they open a campaign account?
No, when you could file with the supervisor of elections and say, raise your hand and say, I'd like to be in the seat.
I don't know. Are you sure
what
that's
that
correct? Because I know all the judges come up and they're there, and I thought there was a week where you've got to file your qualifying papers. It's not like you just can. But we'll see what the record
she filed paperwork in September, and those documents are on the record.
Well, that would be to open a campaign account, wouldn't it? That, obviously, you indicate you're going to run, but the two different things here are opening the campaign account and then actually the qualifying for office. And the fact that someone has not yet opened a campaign account when she had obviously doesn't mean that he's not going to ultimately open one and qualify.
Well, if the issue is that no one could have gone ahead and actually qualified for the race at that time, then there was nobody that was currently in the race.
It's always an open seat then until qualifying occurs.
If no one has expressed an intention to run, and if the question to the candidate was whether there was someone who is going to be running, then the question becomes, is there a misrepresentation when the answer is no one has expressed that intention yet? Just because someone might do it in the future doesn't mean that at the time the statement was made, it was a misrepresentation.
During your rebuttal.
Thank you, Your Honor.
Bar.
May it please the Court, Jody Thompson for the Florida Bar. The issues today are whether Canon 7C6 is constitutional and whether discipline should be imposed for a violation. Those are policy decisions for this court to make, and
the bar is saying. Fact is, we've got 90,000 lawyers, and those lawyers are practicing in the trial courts around the state. And in part, the canon was passed to ensure that there was at least appearance of impartiality. But it's the lawyers that are at risk of this canon being declared unconstitutional. Now, if it's policy, the Constitution isn't policy. It's about whether, so is the bar saying that they're not going to even express an opinion as to whether it's constitutional or not? That it's a policy of the court to decide whether it's constitutional?
Yes, Justice Pariente.
Then this oral argument is really somewhat worthless, because we asked the JEAC if they wanted to, file something. They didn't. The JQC, and therefore you just leave it to the court. Well, if the court thinks it's a good idea, keep it, great. If the court doesn't, the 90,000 plus lawyers are fine. If if judges get to personally solicit for campaign contributions. Is that what you're saying?
I apologize, Justice Pariente. I didn't quite hear everything you said, but
All right.
I think what you said.
I'm saying that, and I'm sorry, I guess I put this down, that the bar is saying that it is up to this court, and the bar and everyone else in this state has no opinion as to whether this canon serves a compelling interest in ensuring the impartiality of the judiciary, and that the 90,000 lawyers represented by the bar take no position as to whether it would be a good idea to get rid of this entire canon, because there's other ways to ensure the integrity of the judiciary. It's just...
Yes, Judge, Justice Pariente.
And I realize you're the messenger. I understand that
Justice
you've got
Pariente.
Let me ask you about the newspaper account. On that, when that conversation between Ms. Yulee and the newspaper reporter was held, was it still several months away from the incumbent being able to qualify?
Chief Justice Polston, I am having difficulty hearing. I do wear hearing aids. This is a transmitter, so I apologize. Could you please repeat that for me?
Sure. When Ms. Yulee had the conversation with a newspaper reporter, was it still several months away from the time for the incumbent judge to be able to qualify for that office?
Yes, Chief Justice Polston. There was still time before the deadline would run, that there was time available for other candidates to file their paperwork and to announce.
Well, help me with the time periods. Give me a timeline of when the conversation took place in relation to what the incumbent judge had to file with the Secretary of State's office.
My recollection from the record is that there were still a couple months before the deadline.
I thought that, again, we can check the statutes. I thought that you can set up a campaign committee. First of all, you can do it even more than a year in advance, because that's part of the canons had been held unconstitutional about when you can start raising money. So you can, but the issue of whether you qualify, I thought those papers were that there was it wasn't like an open-ended 8-month period. I thought that there was like a 1-week period in which those candidates who want to seek a judicial office would qualify.
No, actually, there's a statute now that allows candidates to pre-file, and then when that window period starts, the Secretary of State will file it for you, have it right there. But there's that one statute that allows that to happen. But let me just ask you this, going to this time period here. At the time that the respondent here made the comments, there was no candidate that had filed or pre-filed or done anything.
That is true.
So
there was no candidate, but there still could have been a candidate. There was still time.
But what she said was accurate, but not true.
It was accurate. As the statement, yes, was accurate. But the meaning of, as Justice Kennedy pointed out and Justice Pariente pointed out earlier, that as attorneys, we understand what the meaning of an open seat is. And I believe that in this case, there was a misunderstanding or a carelessness about the terminology Mrs. Williams-Yulee was using, and the record or that we have of that conversation or interview by the newspaper reporter and the respondent was published in the newspaper. The reporter reporting what information was conveyed to her by the candidate. And the public reads the paper and gets their information from the paper. So to see that contradiction in the article, that a candidate is saying one thing, but the reporter is contradicting the accuracy of what that candidate is saying, that is information that is useful and relevant to a voter to determine whether this is a candidate that they would want to vote for, whether it's the best candidate in the race.
Had she said, as I mentioned earlier, had she said, as of this time, I have no opposition, there's an open seat, something like that, that would be okay.
I concur, yes.
Okay.
You concur that she could say this is an open seat? I mean,
No,
you agree that if
time,
the person who is in the seat has not filed their papers, it's an open seat?
No, I apologize, Justice Quince, it is not an open seat. I would concur with the way that the use of open seat in Florida is used, that was described by Justice Pariente and Justice Kennedy, that we understand what the term open seat means. It's the bar's position.
I can agree that she probably could have said at this point, no one else has filed. But I think when you get into a term of that it seems to me that an open seat is a term of art that most of us pretty much understand and I won't go through what has already been said about it. And so she can say at this point, there's no one else who has filed. And that would have been an accurate statement. But to say that that was an open seat, I think, is an inaccurate statement.
Right, and I believe one of the justices mentioned previously that it's almost an omission of the full amount of information.
But the statement at this time, no one has filed, it's an open seat. That may be true, but it's not accurate because at that point in time, no one could file. Because there is a window period, and then before that window period, there's another smaller window period in which the secretary say, "We'll hold it for you." But early in a campaign like that, no one could have filed. So although it's true no one have filed, but the whole thing is not accurate. I mean, does that make any sense? Probably not.
Yes, Justice LaBarge, I think the bar can concede that it could be looked at either way. The explanation that Ms. Williams is making, pardon me, Ms. Williams-Yulee is making, and the position that the bar is taking. And the referee was in the position to evaluate the credibility of the respondent when she testified. And also, it's not an issue of just this one issue. There were many issues that brought into question the veracity of the respondent in this case. We also had, there was not only a solicitation letter, but the loose...
If you would keep your head up, I'm having a hard time hearing you too. So you're saying there were additional misrepresentations by Ms. Yulee?
I am sorry, Justice Quince, I didn't hear your question. I'm having a horrible time hearing.
Were you saying that there were additional misrepresentations beyond the open seat?
Whether you consider them misrepresentations or negligent statements, being negligent as to determining the accuracy of the statement, we had an issue in which the respondent was found not guilty, but one of the issues alleged in the complaint was a loose using of the words public defender and state attorney. Ms. Williams-Yulee representing that she was had been a public defender and a state attorney. Well, those are elected positions. There was an argument made that that also was not accurate. The referee did not find in favor of the bar on that
That's not an issue
one.
here.
But the bar's position would be that the referee was in the position to see the totality of all of the conduct. So it wasn't just one mistake of a solicitation letter, one mistake about using the word incumbent, one mistake about judge-elect, one mistake about not properly supervising, perhaps paying enough attention to her campaign and the information that was being put forth on her behalf. So it is a the totality of the circumstances, I believe, that led the referee to come to the determination that she made regarding the credibility of the respondent.
Is the bar still seeking public reprimand?
Yes, Justice Periente.
I noted that in the judge's recommendations, the argument was made by the respondent that she'd already received punishment due to the various negative articles written about her, and there was no actual harm to the public. The judge said the actions may have caused harm to the public's faith in the judicial elections process. And then there is something else that the judge wrote in there. I'd like you to address it. I also note the respondent testified that she assured her clients who called with concerns due to the recent newspaper article about the instant proceedings that there would be no problems with her representation and nothing was going on. I do not see how the respondent can make such assurances with the instant proceedings and possible sanctions still pending. The respondent also testified she's currently running as a judicial candidate, once again, while these judicial proceedings are pending. Now, the first part about assuring clients that nothing was going on when something was going on, that's not a separate charge, correct? Now, I'm referring to the subsection A on page 6 of the referee's report.
Yes,
that was not a charge that the bar brought against her.
Yes.
Okay, it must have been, she must have testified, I guess, during the proceedings, so this would have been just something that came out during the proceedings?
Something came
Came out during the proceedings before the referee?
I do not know.
Well, it says she testified that she assured her clients. Testified, so you can't tell me whether it was testimony that she gave in these proceedings before the trial, before the referee? All right, we'll look it up in the record. The issue, though, of that she's currently running as a judicial candidate, what's the relevance of that to deciding what sanction to impose?
What is the relevance of it to what?
To the sanction. The judge put it in under the public reprimand recommendation. Mm-hmm. What is the relevance of finding that she was currently running while the proceedings were pending? There's no prohibition in her running again, is there?
No, Justice Periente.
So you don't know what, did the bar say that was a relevant factor in deciding the discipline?
No, Justice Periente. The bar did not raise that.
Okay, and there's no indication that when she ran again, that there was any impropriety in the campaign?
No, Justice Periente.
Okay, so presumably, whatever happens here, she's learned the lesson, and we've certainly had enough in the public eye about not wanting candidates to stray at all from the canons, right?
Right. There were no other cases that came forth from that.
What evidence did the bar place before the referee to establish the alleged impropriety of the statement to the newspaper reporter? Was it only the article itself?
Yes, Justice Lewis.
How does the article in and of itself provide clear and convincing evidence?
The article published the statements made by the respondent and then drew attention to the reporter's argument that those statements were not accurate, and that was reported in the paper. The only other evidence besides the actual article.
And the article itself pointed out, did it talk about Greco's retiring as a judge before this incident?
No, Justice Lewis.
Did it talk about anything about his history of being a senior judge and being unable to do so?
No, Justice Lewis.
Did it talk anything about his being appointed for that position?
No, Justice Lewis.
So really what we're doing is using a newspaper article as a basis, a factual basis for clear and convincing evidence that a lawyer has violated the Code of Professional Responsibility.
Yes, Justice Lewis,
Are there
along
any other
with...
cases in which that's occurred? That seems pretty dangerous to me and really not very much evidence when you use just a newspaper article.
Yes, Justice Lewis, I would concur with you. That was the evidence that was presented. There was not additional evidence. The reporter was not called to testify. But the other evidence that the referee would have considered would have been the demeanor and credibility of Ms. Williams-Yulee when she testified regarding the conversation.
Well, we have to have facts about Judge Greco's history and his position. Do we not? Before you can establish a falsity. So did the referee take judicial notice of these facts?
No, Justice Lewis, the referee did not take any judicial notice about those facts.
It just seems very, very strange to try to prove a case with just a newspaper article. That's just, I understand we're not bound by the formal rules of evidence in a bar proceeding, but I just don't know that I've ever seen even a bar case that the bars prevailed on a newspaper article.
Yes, Justice Lewis, it was not the largest, what the bar deemed to be the worst of the alleged misconduct. Also, there were trial strategies at the time, and for those reasons, the evidence is limited to what's in the record.
Well, I mean, you've got the practical problem that reporters really don't like being called and to subjected to inquiries about their interviews with people they've interviewed and kind of put on the stand and have their credibility challenged about what they printed in the paper. Isn't that correct?
Yes,
kind of
Justice Kennedy.
It might be a prudential matter for the bar to just say, we're not going to go there to haul in a reporter about this.
Yes, Justice
now, whether
Kennedy.
that might be just the problem you've got, but
Yes, Justice Kennedy, the bar would concur with you. And also, although the bar obviously has the burden of proof of proving guilt, I would just add that prior to trial, the respondent also had the opportunity to list witnesses and call witnesses.
Well, isn't the real issue?
I'm sorry, since when do the respondents have the burden of proving the facts upon which the bar's case is based? I mean, as I sit here, I know nothing, as a matter of fact, about Judge Greco, only what I know because we've dealt with him before.
Yes, Justice Lewis.
And that's where we're left. It's not a question about who said what, it's the underlying facts. I mean, we sit here and we're supposed to accept, because a reporter put in an article that Judge Greco was the incumbent, and he may truthfully have been, but that's the basis for the findings. Just call Judge Greco, didn't use his deposition, but nothing in them.
No, Justice Lewis, that is the evidence besides the testimony from the respondent.
I guess I was going to say that it seems to me, even sitting here today, that the respondent would still argue that this was an open seat, so she didn't say anything wrong. And I guess that's what concerns me, is that we're having a difference of views, and I'm, about. She didn't contest that. We're just splitting hairs to say, well, if someone hadn't filed, she can say it's an open seat. And I don't think that we wouldn't want that to occur in the future. So, but that's really the bottom line. They say that she was correct, that it was an open seat.
Yes.
Justice Perry?
Well, I guess I'm looking at the referee's report, and it clearly says Ms. Jenkins asked Yulee about her candidacy and whether there was an incumbent. Yulee responded there was an incumbent, but he had not announced his candidacy. I mean, is that not what the referee found?
Yes, Justice Perry, that is what the referee found. There was an incumbent. Judge Greco had not announced his intention.
Isn't that what she said?
Yes.
So is the bar's position that the newspaper always has to be right?
No, Justice Perry.
Okay.
What she said when? Evidentiary hearing. Is that what she said at the evidentiary hearing?
At the
This is not what was said in the article or to the reporter. This is what she said at the evidentiary hearing.
Correct.
That yes, in fact, there was an incumbent in that seat.
Correct.
Thank you. You're out of time. Thank you for your arguments. Rebuttal?
Thank you, Your Honor. May it please the Court. I know my time is brief. With respect to that last question, Justice Quince, we don't have evidence as to what took place during that conversation. The evidence at trial was Ms. Yulee testifying what she said in the conversation. Okay,
But it was specifically that she said there was an incumbent in the seat. But that's what was said at the evidentiary hearing.
In response to the question of what was said to Ms. Jenkins.
That's what I was trying to clarify.
Yes, but I don't know what was said to Ms. Jenkins. All we know is what's in the newspaper article, which is taken out of context, and there is no supporting evidence in order to hold her to a standard of clear and convincing evidence that she committed a misrepresentation.
Well, does she deny that she told the reporter it was an open seat?
It's not in the record. She has denied it to me. She was never asked that question about the open seat. Barr never asked her about that quote in the paper. I never asked her about that quote in the paper.
Well, but there it is where you're not saying the evidence that the article couldn't come in. Wouldn't it be up to her then, again, to say, I never told that reporter that it was an open seat. All I said was there was an incumbent, but he hadn't yet filed.
Well, actually, it would be the Barr's burden of proof to prove that she said it. And by just having a newspaper article which could contain a mistake, which could contain a misquote, which could contain a misunderstanding, isn't clear and convincing evidence that that's what she said.
Are you telling me that a lawyer faced with that and knowing the Bar has said this was a misrepresentation wouldn't want to say I either said it was an open seat or didn't? And if she doesn't say it, I'm having trouble with that little dance
I understand
around.
that, Justice Perrienche, but I believe the focus had been much more on the line in the article before that, where the line in the article said that the reporter had told, or the candidate had told a Times reporter there was no incumbent for the seat. And so all of the questions at the hearing was, did you ever say that there was an incumbent for the seat? And the answer was yes. I consistently said there was an incumbent in the seat, but he hadn't yet run. And no one really went to that next line where there was a quote, because we were all focusing on the line about incumbent, because that was what was in the complaint, that she said there was no incumbent, not she said there was an open seat.
Gotcha. Okay.
And so that was never an issue.
Appreciate that.
Briefly.
So was the focus of the hearing that the Canon 7 issue, was that addressed at the hearing?
The Canon 7 issue had been addressed at a more of a preliminary hearing on the sufficiency of the complaint. The referee came to the conclusion, which is probably proper, that it would be up to this court to determine whether or not Canon 7C1 was constitutional. There really wasn't a lot of issues with regard to the mass solicitation letter, because she admits that she signed it, and she admits that she read the canon, and she admits that based on a later interpretation, she interpreted it wrong. So the issue is simply, is that canon constitutional? I certainly would like to discuss the Weaver case and the Carey case, which talk about the overbreadth of Florida's Canon 7C1, at least in context, that it is not possibly to be considered narrowly tailored. I don't think there's any doubt about there being an important state interest that's going on here. It is a compelling state interest, but the canon is not narrowly tailored in order to address that interest.
Thank you for your arguments.
Thank you, Your Honor.
The next case on our docket for the day is State of Florida versus SM. You may proceed.
May it please the court, my name is Richard Valentis and I represent the state of Florida. I'd like to reserve 5 minutes for rebuttal. Well, luckily, both sides agree that there are instances where you can score 0 on a risk assessment instrument and still receive detention. So the issue before the court today is whether someone charged with a probation violation who scores 0 or less than 7 on a risk assessment instrument can be detained in home detention with electronic monitoring by the trial court. Basically, the issue before the court is who got it right? Did the 2nd DCA get it right in JLT, or did the 4th District get it right, in this case, SM? It's the state's position that the 2nd DCA got it right because not only did they do a thorough analysis of the law, they actually looked at the risk assessment instrument document, which is the most critical document in a case for pretrial detention care.
One of the strange things about this case is that in the district court, the risk assessment instrument was not in the record. Isn't that correct?
Yes, Your Honor.
Well, now, ordinarily, we don't look at matters that are not in the record before the court below. Now, this is kind of a strange thing here because the detention risk assessment instrument, that's something, it's not in the Florida Administrative Code from what I can see. Nope. It refers to this existence, and then you can go to the department and get a copy of it. So it's something out there. It's a record of the state in that sense, the form.
Correct.
What does that the way that has come here, what impact does that have on this case?
Well, I don't think it has a whole lot of impact because it, I guess, technically did make it into the record attached to my motion to recall mandate and motion for rehearing. So that's how, after the opinion had come out, I was provided with a copy of the risk assessment instrument. And if you look at the plain language of the risk assessment instrument.
This actually was in the record at the district court after the initial decision had issued.
Correct, Your Honor. And I'm referring to page 3 of 5 of the risk assessment instrument. After you go through section 2, there's a little box. It says if A through E are answered yes, proceed to section 3, which is where the scoring is done. Okay? We don't have that here because through the hearings we established that we're just going forward on a VOP. And then it says if each of the above A through E are answered no, the youth must be released unless F through K is answered yes. Well, that's what we have here. J, which was a probation violation, was answered yes, and typically what happens, a child presents with a violation of probation, DJJ checks off J, zeroes out section 3, then it goes before the trial court, and the trial court does have the discretion. The one thing the Fourth is absolutely right about is the trial court is not bound to put a juvenile in home detention with electronic monitoring just because she's accused of violating the terms of her probation. That's absolutely right. However, the judge did exercise his discretion in this case, and then on a habeas petition to the fourth, without a copy of the risk assessment instrument, which this is why the second DCA's opinion, in my opinion, is correct, because they actually read from the language of the document that the fourth didn't have, and it directs you that pretty much what DJJ calls automatic qualifiers are what exist in F through K, and that's what we had here. And as far as my argument on Section 2, I mean, the case law... Yeah.
So your argument is the fourth district got it wrong because they did not have the risk assessment instrument before them?
Correct. That's one, Justice Quince?
Was the argument made by the state about Section J?
Oh, absolutely. And that was in my response.
Okay. And so what did the fourth district say about Section J, or was it discussed?
No, what they said, they decided to create a presupposition. See, they didn't actually talk about J at all because they didn't have the document.
I'm sorry.
I'm sorry. They didn't talk about J on the RAI at all because they didn't have it in front of them. What they talked about was the statutory section that basically J comes from. And they decided to make the logical leap that, well, because a trial court can continue the detention of someone on probation, somehow this statute presupposes a score on the risk assessment instrument, which really doesn't make sense because the legislature delegated the authority of creating a risk assessment instrument to the Department of Juvenile Justice. There's no statute that requires any points whatsoever in this document. So how the fourth...
It's still interesting to me why this risk assessment instrument wasn't before the court. The trial court had it.
Correct, but
wait a minute. Let me.
Yes, I'm sorry, Justice Quince.
The trial court had that instrument before it made its decision, correct?
Correct.
And so why wasn't it a part of the record?
Well, it wasn't a part of the record because the defense didn't give it to the fourth as an attachment, because this is a habeas petition. The only record they get is what the defense gives them, and they didn't give it to them.
And on a habeas petition, the respondent cannot attach anything to the response?
I would believe I could if I had it.
Well, didn't you have it at the trial court?
Well, the 19th Circuit State Attorney's Office had it, absolutely. But the way this came in, I got it on the 17th. My response was due on the 18th. And I asked them for it. There's no one's name attached to it. So, I mean, in theory, yes, Your Honor.
So in theory, yes, the state could have attached it to their response to the habeas petition.
Correct.
And that,
but it's not my obligation.
To me, would have been what would have been done in the ordinary course.
Okay.
If they're saying I am entitled to not be on home detention, and you're saying they absolutely are because Section J says that they can be put on home detention because of the probation violation. I would think in a situation where both people, there's no official record and people are attaching whatever to support their position, that's what would have been done.
Well, see, what happened in the initial response, Your Honor, was I didn't argue that. My argument was...
You did not argue that?
I did not. In the original response, my argument was, look, I didn't get a copy of the transcripts. I didn't get a copy of the risk assessment instrument. How in the world can you reverse what the trial court did when you're not providing these integral documents? That was my argument.
And you never, and your secondary argument was not that it was a violation of probation alleged, and so clearly the trial judge could put them on home detention.
Well, that didn't come out until the rehearing after I got a copy of the risk assessment instrument. And again, this is something that the 4th District just presupposed as opposed to actually looking at the document. And on my second point, the law is pretty clear. If you have a situation where the judge issued home detention, secure detention, without the use of the pivotal risk assessment instrument, and the habeas is taken up, that's almost per se reversible error.
I mean, there are circumstances under criteria F through K of the RAI
where someone can be detained without with a zero, correct?
Absolutely, absolutely.
And I think J provides that violation of probation is one of them?
Yes.
Okay. So what is the argument that's being made here?
Well, the argument
why the
is,
judge was wrong?
No, the trial judge was right.
I'm guessing.
They argued to the fourth
Right.
DCA that, no, you have to have, not only do you have to have, one of these F through Ks, which is contrary to the plain language of the document, but also you need a certain score to get someone in home detention with electronic monitoring, and that's nowhere in the statute, and it's nowhere in the risk assessment instrument, and that's why the fourth DCA got it wrong, and the second DCA got it right. And if the court doesn't have any further questions, I'd reserve the rest of my time for rebuttal.
Thank you.
Thank you, Your Honor.
My name is Renee M. Rancourt, and I'm here on behalf of SM, the respondent in this case. We're asking the court today respectfully to approve the decision of the 4th District Court of Appeal in SM and reject the decision of the 2nd District Court of Appeal in JLT. We're asking the court to hold that a child cannot be held in detention absent a qualifying risk assessment score, a statutory exception to the score, or the trial court having made written findings of clear and convincing reasons why the child can be held without a score.
So what do we do?
Before you go any further, could I ask you, you don't have any objection to our looking at this and considering this detention risk assessment instrument in this case, do you?
No, Your Honor.
Okay, so everybody agrees this is fair game, and what's here is appropriate for us to look at.
It's appropriate for the court to consider, Justice Kennedy. However, it was not provided on the petition for writ of habeas corpus because I think it scored 12 or 15 points at the trial court. When the case came up for detention review hearing, the state said and agreed that the child should be scored 0 points. So the defense agreed to 0 points.
All
and
right,
I don't think physically that the trial court made the correction on the risk assessment. I think it would have confused the issues when there was a stipulation to 0 points and the detention order indicated that the child scored 0 points.
Well, let me ask you this. What does this language mean on the risk assessment form that says a youth is alleged to have violated the conditions of the youth's probation or conditional release supervision? The youth may be held in a consequence unit if one has been designated and is made available by the department. If that unit is not available, can be placed on home detention. What does that language mean? It seems to me that that language clearly says that if they have alleged to have a violation of probation, that they can be held in home detention. That's what happened here. There was an alleged violation of probation, and the trial judge said home detention.
Well, Justice Quince, the risk assessment instrument is prepared by the juvenile probation officer upon intake, so upon the child's arrest and being brought to the detention center. It's used then to determine what can happen to the child for the next 24 hours before being brought before the court for a detention hearing. So the initial determination is made by the juvenile probation officer whether they should be released outright, placed on home detention, placed in secure detention, pending review by the court to determine what's appropriate and the need for continued detention. At the detention hearing, the court
this is only, let me make sure I understand what you just said. This RAI form is only good for the 24 hours before he or she is brought before the court?
It is initially good for that, and then the court can consider it and also consider any other factors to determine whether there's a need for continued detention. But the case RAP v. Parkins was a first district case, and that case said that the home detention provision that you just read, Justice Quince, is basically a statutory maximum for what can happen as far as detention when a child's charged with violation of probation. It's interesting that in this case, the child was alleged by the state attorney in open court at the detention hearing to have violated probation, but the case number that we're here on, the case number that the child was detained on, was not even a violation of probation. It was a new law violation, and at the detention hearing, the state attorney and the probation officer just said, well, the child's also on probation, but was never detained on that violation of probation, was detained on a new law misdemeanor, using the fact that the child was on probation.
But I guess I don't know about these risk instruments and things, but are you telling me that you have to have two different cases if a child is alleged to have committed an offense and the child is on probation, and so now you're also alleging a violation of probation? You need two different instruments?
I don't think you need two different instruments, but I think you do need to have a violation before the court. I think there needed to be an affidavit of violation to let the court know that a violation of probation was going to go forward before they were to include that in the instrument and as part of the detention hearing.
Well, let me ask you again about the language that's on the form, because it seems to be very clear that if yes is checked here on J, which it was, that you don't even go beyond Section 1 to the risk assessment in Section 3. Isn't that correct?
No, I don't think that's correct. To do so, to automatically say every child accused by anyone, even if not formally accused in an affidavit of violation, anyone accused of violation of probation would be automatically subject to home detention, that would completely obviate the need to even have a detention hearing. We could just have the juvenile probation officers at intake follow a set of rules. In this case, you detain. In this case, you don't. This gets home detention. Why have a detention
Well, but
hearing?
I'm just reading the form. I understand that might not be the ideal way to do it, but you're not challenging the legality of the form, are you?
No, as far
Okay.
as the first 24 hours of detention, yes. I think that if the JPO decided not to do the points, that they could hold the child in home detention for 24 hours pending that detention hearing.
But again, this instrument is also used by the judge to determine whether there's going to be further detention. Once the initial intake decision is made, if I'm understanding this correctly, and then this detention hearing is held, and this instrument is used in that process of the detention hearing. Isn't that correct?
Yes, Justice Kennedy.
Well, and so when the judge is looking at this, it seems to me that it's a category mistake that you are making, and that the district court made, and that the second district didn't make. They understand that if a youth is alleged to have violated the conditions of the youth probation or conditional release supervision, okay? When that gets checked yes, then there's no going on to the next step.
According to the form, not according to the law, not according to statute, not according to the case law.
So you are disagreeing with the form. A minute ago, I asked you if you were challenging the legality of the form, and I thought you said no.
That's correct, Your
Now,
Honor. I'm not.
It seems like to me that what you're saying now is, well, this form really doesn't conform to the statutes. Am I missing something?
The form doesn't make a lot of sense. The form needs a lot of changes.
Well, the statutes might not either. I mean, but you've got to look at all of it and try to figure out.
It is clear that the detention of juveniles is governed entirely by statute, and strict compliance with the statutes is required. So regardless of what the form wants you to do, you have to follow the statutes. The statutes require that one of those admission criteria be met, and calls those admission criteria A through J in 985-255. So it doesn't exclude F through K, it says A through J. And then it also requires that the risk assessment be considered. So the statutes talk about those being two different things. There's an initial threshold of meeting the criteria, and then you go to the points. And that's what RAP says. That's what TKB says. It says it's a two-step process. That first of all, you have to meet the admission criteria. And if you do, then you proceed to a tallying of the points to determine whether the risk assessment score is there. So we have case law and statute saying that that's a two-step
So you're
process.
saying the form is fine for the 24 hours, but for the later assessment, the form does not comport with the statute?
Yes, Your Honor, I think that the judge needs to go further and conform with the statutes and the case law and tally the points. So if the juvenile probation officer decides not to do that for 24 hours, that's fine, but the court's going to need to consider that and have that. Or the state and the defense can agree to it, but they're going to have that tallying of points in order to continue detention. They've got to decide that the criteria
And where
is
does that clearly say that in the statute?
985.245.
985.
.245, subsection 1.
Okay.
It doesn't say score in that part, but it says that the criteria must be met. It says all determinations and court orders regarding the placement of a child into detention care shall comply with all requirements and criteria provided in this part and shall be based on a risk assessment of the child unless the child is placed into detention care as provided in 985-2552, which is just one of the exceptions, domestic violence exception.
This is the risk assessment. The form is, it seems like that takes you, what you just read there takes you around to the detention risk assessment. And this risk assessment instrument says, don't go to the points that you get, it's either going to be consequence unit or home detention if there's a violation of probation, alleged.
Again, I don't think it clearly says don't go to the points, and I don't think there's anything in any of the statutes that say don't go to the points.
Right on the form there, right below, also, in addition to what's on the page that we referred to earlier, on J there, where it's got, describes the, or lists the violation of probation or conditional release, right below that, it's got a box to check, either consequence unit or home detention. And I understand there are restrictions on when you can do a consequence unit as opposed to home detention, but it seems to clearly contemplate that it's going to be, it may be one or the other, doesn't it?
Right, again, I think that's for the first 24 hours, and I think RAP got it right in the first district when they said that's the maximum you can do on when you just have a violation of probation. If there are no more questions, I'd conclude by asking you all to approve the decision of the 4th District.
Thank you for your argument.
Just briefly, Your Honor, and therein lies the problem with why the 4th District got it wrong. There is nothing in the statutes whatsoever about scores. What happens is the scores are a creation of the Department of Juvenile Justice through Section 985.245, where they were delegated the authority to do it. In fact, the cases she cited are absolutely wrong if you look at the plain language of the form, because it's not truly just a two-step process. Because if you go to the first step and you find someone, let's say, oh, well, they committed domestic violence. Wait a second, the risk assessment form says you don't even go to the points. So how could it be a two-step process in every situation when the document itself says, no, you don't go to the score when you have someone checked off solely with D. So that is the problem I think that the District Court of Appeal ran into, is they equated score with a qualifying risk assessment instrument, which is what the statute says, which is what the 2nd District recognized. And the risk assessment instrument, there is no discretion. I mean, this is something that's created at intake, but the trial court has to consider that document. And if we were to say, which I believe the law is, you can continue this person, check off the violation of probation, there is still a purpose for a detention hearing. You come to the detention hearing, the judge still has the discretion to say, no, you get to go home. If the judge hears from mom and dad and says, hey, you know, it's going to be better. I don't need an electronic monitor on you. This is your first time offense, and mom and dad are going to take care of you. Why involve this state in it? I'm comfortable with that. They can do a lot of things, but they don't, and the 4th got that right. The trial court does not have to sentence home detention with electronic monitoring. And I thank you for your time.
Thank you for your arguments. Court is adjourned.
All rise.